and we will kick off our National Disability Employment Awareness Month webinar, Know Your Employment Rights. Before we get started, I want to just give some housekeeping tips for accessibility purposes. Tonight we will have ASL, and if you need the ability to multi-pin, please put that need in the chat. Feel free to do it directly to me if you would like. Also, if you are speaking today, please do your best to give a brief visual description of yourself for accessibility purposes. I will do that for myself right now. I am a small white woman with kind of bluish hair in an office wearing a headset. And also, if you are speaking, please make sure to identify yourself for accessibility purposes. And with that, I'm going to go turn it over to our first presenter.
Great. I think that's me, and I think we can move to the next slide, and we will introduce the host of this evening. I'll start by introducing myself and giving a short description. My name is Jody Sugarman-Brozan. I'm the Deputy Chief of the Worker Empowerment Cabinet and the Director of the Office of Labor Compliance and Worker Protections, one of your hosts this evening. I am also a small white woman with gray hair, and I'm very excited to be working with you all this evening, and hope that we can share a lot of really important information and get your questions answered. I'm going to introduce my colleague Chan, who will then introduce our other speakers to give you a quick overview so you know who'll be talking with you this evening, and then we will jump into content. Chan.
Thank you, Jody. Thank you, everyone, and good evenings. Welcome to the October webinars on rights of workers with disability. And as my colleague have said, my name is Chan. I'm the Senior Policy Manager at the City of Boston Worker Empowerment Cabinet. As you may have heard from our Deputy Chief, we have been very honored to be a part of an effort to advance worker rights and improve their working condition. And I'm going to pass it over to our another colleague from the MOD to do a brief introduction about himself. Thank you.
Hi, I'm Julia O'Leary. I am the General Counsel at the Massachusetts Office on Disability. And with me, I have Naomi Goldberg, who is our Assistant Director for Disability Rights. Mass Office on Disability provides information, guidance, and training on disability-related civil rights and architectural access. We help workers understand their rights and obligations under disability laws and how they apply in different situations so that they can better assert their rights and comply with the law.
Great. I think we can move to the next slide and jump into our webinar content. So again, my name is Jody Brozan. I am the Director of the Office of Labor Compliance and Worker Protections at the City of Boston. We enforce the city's labor policies and are a central resource for workers' rights information and resources. And I always start by every webinar by saying that the rights that we are about to discuss and the information we are about to provide, it applies to almost all workers, regardless of immigration status. The only exception is that undocumented immigrants don't have, without work authorization, cannot receive unemployment benefits. Otherwise, everything that we will be talking about this evening applies to all workers. And we can go to the next slide. So I'll start with issues related to wage and hour. And we're going to be reviewing a number of general rights related to your right to be paid fairly, your rights around health and safety, and your rights around paid leave, before handing it to our colleagues at MOD to go into more specifics around rights for workers with disabilities. So first and foremost, the minimum wage in Massachusetts is $15 an hour. That means that every worker in Massachusetts, with a couple of exceptions, should be paid at least $15 an hour. Agricultural workers are exempted from the $15 an hour and can be paid a minimum of $8 an hour. And as most folks know, there is restaurant and service employees can make a minimum of $6.75 per hour. However, service employees who work in restaurants who receives tip, the $15 an hour still applies, and your rate, your final rate per hour of the $6.75 per hour plus the $15 an hour must reach at least $15 an hour. And one thing that we encourage for folks who are work in a restaurant or service employees who receive tips is to keep a really good record of the amount that you've been paid and the tips that you've been paid to ensure that you are making at least $15 an hour and that your employer is making up the difference where needed. And next slide. Overtime is another important law, a wage and hour law. If you work more than 40 hours a week, you must be paid 1.5 times your hourly rate for every hour worked over 40. So for instance, if you're paid $18 an hour, your overtime rate is $27 an hour. And this law applies to over 40 hours a week, not per day. In other words, if you work 10 hours today, you're not entitled to overtime until you reach the over 40, and it's an additional 42 hours in a week. Some employees are exempt from overtime. These are salaried employees like executives, professional, and some seasonal workers. But if you are paid hourly and you work over 40 hours a week, you are entitled to overtime. Next slide. Pay stub. This is a very important law, and it was actually something that workers in Massachusetts had to organize to ensure that all workers would receive a pay stub with critical information that allows you to see the name of your employer. And that may seem like a no-brainer, but if you are a temp worker, sometimes it's unclear who your actual employer is and who you must, if there are problems or issues, who you are supposed to talk to. The date of the payment, the number of hours worked, the hourly rate, any deduction money, any deductions made, and an employer cannot deduct money from a worker's pay unless the law allows, like withholding taxes. And there are certain deductions that cannot be made from your account without your permission. And an employer who requires a worker to buy or rent a uniform must pay for the uniform or promptly refund the actual costs to the worker. So we really try to make sure that folks understand that you must receive a pay stub, and the pay stub should have this information. And this allows you to ensure that you've been paid fairly for the correct hours and that the deductions that were made are the correct deductions and there have been no illegal deductions made to your paycheck. Next slide. You also have the right to earn sick time here in Massachusetts. And this was another big victory for people who advocate for workers and workers who organize to get an earned paid sick time law. It requires that most workers in Massachusetts have the right to earn and use up to 40 hours of job protected sick time per year to take care of themselves and their family members. Workers must earn at least 1 hour of earned sick time for every 30 hours worked. If your employer and you work for a company with 11 or more employees, they must provide that paid sick time as paid. For fewer than 11 employees, they must provide the earned sick time off, but it doesn't need to be paid. Next slide. You also have the right to parental leave. The Mass Parental Leave Act requires employers with 6 or more employees to provide no fewer than 8 weeks of unpaid leave to employees for the birth or adoption of a child. Law is gender neutral, and leave must be given to employees who request it regardless of gender. And this parental leave applies after you've completed your initial probationary period, which is set by the terms of your employment and cannot exceed 3 months. And generally folks have to give 2 weeks notice before this leave. However, the law permits you to provide notice as soon as practicable if the delay is for reasons beyond your control. Next slide. You also have the right to paid family medical leave. This is another big victory for workers in Massachusetts. Most Massachusetts employees are eligible for up to 26 weeks of combined family and medical leave per benefit year. You may notice this on your paychecks. You may see a line that says PFML. Those are deductions that are made to help pay for paid family medical leave. You must be paid on a W-2 with taxes deducted. You can take leave for any qualifying reason, and a qualifying reason is the cause or event that makes you unable to work and eligible for paid family medical leave benefits. And below you can see some of the qualifying reasons: caring for your own health conditions, or a pregnancy or childbirth, caring for a family member, bonding with your child during the first 12 months after birth or adoption. And again, there's great information on the Attorney General Fair Labor Division website. I will put that in the chat, that describes in more detail paid family medical leave and earned paid sick time. Next slide. You also have the right to a workplace free of sexual harassment. Gender is a protected class in the discrimination laws in Massachusetts and federally. And an employer is liable for sexual harassment of employees by managers and persons with supervisor authority, regardless of whether the employer knows of the conduct. And an employer may also be liable for sexual harassment committed by persons without actual or apparent supervisor authority, such as coworkers. And an employer may also be liable for the sexual harassment of its employees by certain non-employees, like customers, patients, clients. Massachusetts law requires employers with 6 or more employees to have a written policy against sexual harassment, and that employer's policy must include notice to employees that sexual harassment in the workplace is unlawful, and that it is unlawful to retaliate against an employer for filing a complaint. The policy also should assert the employer's commitment to investigate any complaint of sexual harassment. And again, you can find information about this on the Mass Commission Against Discrimination's website. Once I finish talking and pass on to my colleague, I will be sure to put those links in the website, in the chat for you. Next slide. Also, you have the right to workers' compensation if you are injured. Workers' compensation is a type of insurance that must be paid for by your employee. If you are injured or made sick from work, your employer must notify their insurance company about what happened, and the name and phone number of your workers' compensation insurance company must be posted at work. You should see that when on the walls of your workplace. If you're covered by this law, no matter how many hours your work or jobs you have, even if you're paid in cash and regardless of your immigration status, and you're entitled to payment of medical bills for the injury or illness if you keep working 60% of your average weekly pay if you were disabled from work for 5 or more days. You also are entitled to transportation costs for medical visits, payment if you can't return to work because of the injury, payment for loss of hearing, scars, loss of eyes or limbs. So workers' compensation insurance is a really important benefit that is open to all workers and required by employers regardless of immigration status. Next slide. And that workers' compensation is obviously connected directly to your right to a healthy and safe workplace. The Occupational Safety and Health Administration is a federal law that entitles you to a safe workplace, regardless of your documentation status. Your employer must keep your workplace free of known health and safety hazards, and you have the right to speak up about hazards without fear of retaliation. You have the right to receive training in a language you understand. You have a right to work on machines that are safe and well maintained. If your job requires safety equipment such as gloves or harness or lifelines for falls, your employer must provide those. You must be protected from toxic chemicals and informed that if you are working with toxic chemicals, your employer must inform you what you're working with and the correct protections. You can request an OSHA inspection if you believe your workplace is unsafe. And your employer must report injury or illness. And you have the right to review records of work-related injuries and illnesses from your employer. and see results of any test taken about workplace hazards, air quality, etc. With that, I am going to pass it on to my colleague Chan, who will go through a few more slides, and I will add a couple of things into the chat for resources.
Thank you, Jody. Once again, folks, good evenings. My name is Chan. I work with Jody closely. And as she have mentioned a lot about rights available to you as an employee, so I'm going to be talking about rights to a workplace free from discrimination. So, generally speaking, employees are, mandated to establish a safe working environment free from discrimination and harassment for all employees under the law. The anti-discrimination law prohibit any form of, unlawful discrimination that's include harassment based on membership in a protected class. So protected categories include race, national origins, age, color, religion, disability, gender, sexual orientation, gender identity, or any other category protected by the state and federal law. So the anti-discrimination law also prohibit, retaliation against an individual who complain of discrimination and apply to employer with 6 or more employee and any employer of a domestic worker, regardless of the employer's size. So here in Massachusetts, it is illegal for an employer to ask certain question about a job applicant or an employee criminal record. The law also prevents employer from seeking disclosures on job applicant criminal record information. So the form of discrimination may include disparate treatment, harassment, both sexual and non-sexual, and failure to provide a reasonable accommodation based on disability and religion. Massachusetts Fair Employment Practice Law also prohibits discrimination in employment on the basis of disability. Qualified handicapped persons are, entitled to reasonable accommodation unless that accommodation presents an undue hardship to the employers. Next slide, please. Thank you. And next is so important, domestic workers. So domestic worker has been, historically excluded from basic labor protection for long. And in Massachusetts, the Domestic Worker Bill of Rights is a set of legislation that protect domestic worker basic workplace right. The Domestic Worker Bill of Rights apply to nannies, housekeepers, house cleaners, caretaker, regardless of their immigration status, working in a private home. Domestic worker normally play a vital role in household across the state, providing essential cares and support for families and individual. So it is very important for domestic workers and the employers to understand the legal protection that are available under the law. The right of the domestic worker in Massachusetts, domestic worker in Massachusetts here in our state are entitled to various rights and protection. That's include, minimum wage that my colleague have mentioned earlier, overtime pay, worker compensation, anti-discrimination protection, paid time off, notice of termination, safe and healthy working environment. So while many workers may not, many employer may not comply with these requirements, so domestic worker can take various steps to enforce their rights, including, keep record of the hours they work, file a complaint. So should any violation happen, the worker can also file a complaint with the Massachusetts Attorney General's office. Next slide, please. Okay, this is something tricky. So retaliation. So your employer cannot retaliate against you for asserting any of your workplace right. Illegal retaliation may include, calling and threatening to call the immigration department or the police, threatening to get you deported back to your countries, threatening a worker or their family with physical or any other harm, fighting worker, or reducing the hour. So this is illegal. And next slide. You have rights to organize. So you will not be retaliated against if you are expressing your idea or you join your coworker in a range of activity and express your concern about work issue that matter to you. Whether or not you are represented by a union, employer cannot threaten, discriminate against, or otherwise take action against you for organizing or talking with your coworker about the working condition. So next slide. Okay, so this is something that I want to mention. So in an effort to ensure that workers reach the full potential and provide the ability and resources for them to thrive in the workforce, the Office of Labor Compliance and Worker Protection has been partnering with worker centers and also nonprofit organizations to host a number of clinics in different neighborhoods across Boston. And the goal of the clinic is to help, connect workers with agencies or with organizations that deal with workplace issues. The first webinar is in East Boston. It's on November 20th from 4 to 6 p.m. The locations and the date has been put it on the slide here. And feel free to go to the website as shown here in the slide decks to RSVP the event, and feel free to encourage to bring any issue that you may experience at workplace. We have representative from various governments and non-government agencies to help get your question answered. So you are encouraged to attend either one or all of the scheduled webinar clinics here throughout different neighborhood in Boston. So next slide. So as we dig down to the right specific to people with disability, I'm going to invite a representative from the Massachusetts Office on Disability to continue on providing the information. Thank you.
Hi, thank you. So as I said earlier, I'm Julia O'Leary. I'm the General Counsel at Mass Office on Disability. I am a white woman with dark blonde, kind of shoulder-length blonde hair. I've got a gray background behind me with the Mass Office on Disability logo, and our website, which is www.mass.gov/MOD. So we're going to talk about kind of basic protections under the Americans with Disabilities Act today. Really the core principles of the Americans with Disabilities Act as it pertains to employment is non-discrimination and reasonable accommodation. So the act generally prohibits discrimination on the basis of disability, and that includes any action, inaction, or different treatment because of an individual's disability. So if something bad happens to you at work and it was because of your disability, that might be discrimination. If it's because of your disability. The ADA also talks about reasonable accommodations, and a reasonable accommodation in the workplace is really any change in or exception to policies and procedures, how you do your job that enables an individual with a disability to have equal access in the workplace. Reasonable accommodations are going to be based on a disability-related need. So it needs to be tied to your disability. So for example, someone who is blind might need to use a screen reader software at work in order to do their job. That would be related to their disability, but they might not have a disability-related need for a standing desk. If there isn't a need for that based on their disability, right? So it's that change to the workplace necessitated by someone's disability. And so this can be, a variety of things. And we're going to talk more about sort of how to go about requesting a reasonable accommodation and what that process looks like as we get into this. Reasonable accommodations are going to be evaluated on a case-by-case basis. This is a very individualized process. And just because one employee with a disability had a particular reasonable accommodation doesn't mean that that same accommodation is going to work with other employees with the same disability or other employees with different disabilities. It's really going to be an individualized process to figure out what is going to work for this person in their job to have access to the workplace and be able to perform the essential functions of their job. I think it's helpful to understand when an employer could deny a reasonable accommodation request. An employer can deny a request for reasonable accommodation if it would fundamentally alter the position or the type of services that your employer provides. So an example of a fundamental alteration might be a mailroom assistant whose job it is to gather in the incoming mail and sort it and put it into people's mailboxes or distribute it amongst staff. That's probably not a position that could be done via telework. So if someone who is a mailroom assistant was asking to work remotely, that might not be reasonable because it would really fundamentally alter the nature of their job, which really is needs to be done in person. That's not to say that there aren't potentially workarounds that an employer could make for that person, but that's just an example where it might not be reasonable. Another reason that an employer can deny an accommodation request is if it would create an undue financial or administrative burden for the employer. So this just means that the requested accommodation is either really expensive and something that the employer can't afford, or it's just unworkable and too difficult to implement. This is obviously a pretty subjective standard. The court is going to look at going to sort of weigh the different interests here when it's saying, like, is this really an undue financial or administrative burden? So it's going to look at sort of the impact, the financial impact that an accommodation might have on the overall budget. They're not looking at sort of specific program budgets, but the entire budget of the organization, of the employer. And then in terms of administrative burden, they're going to really need the employer to show some hardship there. An employer can also deny a reasonable accommodation request if it would pose a direct threat to the health and safety either of the employee or other employees at the organization or members of the public. So if it's going to create a health risk or a safety risk, so maybe if an employee needs to take medication at work that would make them drowsy and unable to operate heavy equipment, that might not be reasonable because it would be a direct threat to health and safety. Employers can also deny a request for reasonable accommodation if they're not able to determine that the employee is an employee with a disability or that the requested accommodation is necessary because of a disability-related need. So as an employee, it's helpful to provide clear information. We're going to talk more about this as we go in, that your accommodation is really tied to your disability, so that that's really clear for your employer. I'm going to hand it over to my colleague, Naomi.
Hi, everyone. My name is Naomi Goldberg, and I am a white woman with shoulder length brown hair, and I am wearing a tan shirt, and I am, there's a background behind me that's, I think it's blue. Julia said it's gray. I don't know. Sometimes people see things differently, but it's a Mass Office on Disability logo is in the corner. Okay. Let's see, where am I? Okay, self-disclosure versus self-identification in employment settings. These are two terms that we hear about and they sound similar and people often use them interchangeably, but they mean two different things. So first, it's important to note that an employee does not have to tell their employer that they have a disability unless they have difficulty in the workplace due to their disability and need some kind of reasonable accommodation that Julia just referenced. They need that from their employer to address the difficulty that they're having. And again, we're going to get into that reasonable accommodation later. But I am referencing it now just to point out that an applicant or an employee does not have to disclose their disability unless they're having disability-related difficulty in work and want to request an accommodation. But this doesn't prevent someone from choosing to tell an employer about their disability because they want to. And I'm just trying to highlight that that's really a personal decision. For some people, disability, they feel that it's a big part of their lives, and part of connecting with people, involves sharing important parts of their life. Some people feel that way. Other people might choose to disclose because they want people to better understand how they work. For example, maybe an employee with ADHD has informally put some systems in place at their workstation to keep themselves organized, and they want their colleagues to understand why they may be doing something like that. So they tell people about their disability. Maybe a person with a seizure disorder would just feel more comfortable sharing that they have a seizure disorder up front because they'd feel more comfortable in case they happen to have a seizure at work. But in any of these examples, the person chooses to disclose for their own personal reasons, not because they're having difficulty, not because they need anything, but simply because they're comfortable sharing information about themselves. So self-disclosure just means you're telling someone that you have a disability at work. It's informal and it's a choice. At the same time, there are also people with disabilities who would choose not to disclose for a number of reasons. Some people really prefer to keep their private lives separate, or their personal lives separate from work, and for that reason might not want to share anything about their life, including a disability. And a lot of times people fear the stigma, possible discrimination from sharing that they have a disability. So again, all that said, it's just a choice. It's not an obligation to tell someone that you have a disability unless you're requesting accommodation. So self-identification, it actually refers to a formal process that is used by some employers, and it's used for the purpose of affirmative action. So not every employer is affirmative action employer, but larger employers such as the state invite applicants and employees with disabilities to self-identify, or in other words, just tell the employer that they are a person with a disability for the purposes of affirmative action. In doing so, they aren't sharing the particulars of their disability limitations. They're just saying, I'm a person with a disability. And this status may be beneficial with respect to things like hiring and promotion, depending on the particular situation. In terms of the employer, self-identifying is helpful to the employer because it gives them a good gauge of whether they're doing a good job hiring people with disabilities. So just a few other things to know if you happen to work for an employer who has a self-identification process. You would need to know that the information that you're sharing is considered to be confidential. It's kept separate from, an employee's file. And also you should know that self-identification is not the same as requesting a reasonable accommodation. It's a completely separate process. So if a person had self-identified with their employer and then 2 years later they wanted to request an accommodation, they would just have to follow whatever process that the employer had for requesting an accommodation. They would not look back and say, hey, I already did this through self-identification. They're just two completely different things. Okay, next slide, turning it back to Julia.
Thanks, Naomi. This is Julia. You might, after Naomi talked about sort of the differences between self-identification and self-disclosure, ask, why should I self-identify at work? Self-identification can benefit employees by conferring affirmative action status if your employer has that kind of a program, And that can have benefits in hiring, promotion, and it might provide protection in layoff situations, depending on your employer's program. As Naomi mentioned, when more people self-identify, stigma around disability in employment is diminished. When people see people with disabilities having success in the workplace, it sort of reinforces the idea that people with disabilities are good employees who are able to perform the job just as well as their non-disabled counterparts. So it's really important, to sort of make people aware that disability doesn't necessarily mean that someone is not going to be able to do a job or is not going to be a good employee. Self-identification sometimes also prompts people with disabilities to consider whether they need accommodations. You might not have thought of yourself as an employee with a disability, but maybe, as Naomi had talked about earlier, you have sort of some informal accommodations that you have set up for yourself at work. Maybe you have a certain flow to your work day that helps you focus better. Maybe you need to schedule your breaks in a certain way. Formalizing that through the reasonable accommodation process might be a good way to protect yourself at work if you're worried that a new supervisor or a new manager is going to come in and sort of try to modify how you're doing things. So if you need those things because of your disability, you might want to consider whether you want to formalize that accommodation and self-disclose. And then finally, as Naomi mentioned, someone's disability status must always be confidential by the employer. So while you can share your disability status with whoever you want at work, your employer cannot share that information and needs to keep it confidential. So back to you, Naomi.
Okay. Okay. So when do you contact your employer's human resource department or the ADA coordinator if your employer has one? We have a number of bullets here. I'm going to just start with the third one because I think it kind of speaks to all the points. You reach out, whether it's to an HR person or the ADA coordinator because you're encountering a barrier at work related to your disability. It could be a disability related barrier that results in difficulty applying for a job or participating in an interview process, or it could be a barrier to performing the job itself or anything related to working for the employer. You may or may not know what's going to solve this barrier for you, but you're facing one. So that's why you're reaching out. Maybe you're reaching out because you know that there is a certain tool or device that will help you effectively do your job because of your disability. For example, maybe a person who has limited dexterity in their hands is having more and more difficulty typing, and they know that there's speech to text software out there that might make things easier for them with the typing that they have to do. Maybe you need to modify your work schedule or your work location because of a disability, or attend doctor's appointments regularly related to your disability. And maybe you need any other change within the workplace because of a disability. So I'm sorry. So a person, let's say a person who has difficulty with concentration and is finding that their open work environment is difficult, reaching out to HR would be a first step for someone like that and exploring potential ways to address that. I mean, even if you're not sure what you need, you're saying you have an issue and that's a good time to reach out to HR or the ADA coordinator. And maybe you can identify the disability related difficulty, but you're just not sure what to do. Another example of when to reach out to HR or the ADA coordinator, and it's not really here and it's not about an accommodation, but let's say a person finds that they're experiencing a certain kind of treatment or behavior by managers or supervisors or colleagues that's related to their disability, and that might also be a good time to reach out. Next slide, Pascal.
So we're going to kind of focus in on what a reasonable accommodation is. And like we've said before, a reasonable accommodation is any adjustment or alteration in the workplace that enables someone with a disability to apply for jobs, perform the essential functions of their job, or enjoy the benefits and privileges of employment. And this can be a wide variety of adjustments, alterations. It can be something like a communication aid or services. So maybe that's providing, you know, ASL during meetings. Maybe that's providing either a CART reporter or other live transcription services during meetings. Maybe it's providing equipment. That might be, another monitor at your desk. It might be an adaptive chair. It might be other tools that allow you to perform your job. It could also be removal of barriers. So maybe the bathroom in your office isn't accessible to your power wheelchair and you need those barriers removed. It can also be reasonable modifications of policies, practices, and procedures. And this is where things can get really creative. You can have maybe your disability means that you have a hard time waking up early in the morning, and that 9 o'clock start time and your office is really challenging for you. Maybe you need to start your work day at 10 or 11 and shift your day later, and maybe that's going to be workable for your employer. Maybe it's not. Maybe you need a different way of receiving performance feedback because your disability makes the way that you traditionally receive performance feedback really challenging. And so you need to have that in a different way. There's sort of nothing that is, definitely not a reasonable accommodation. It all depends on, what you need to do your job because of your disability. So it's going to be really fact specific, and how you're going to arrive um, at that reasonable accommodation is through the interactive process. And so your employer doesn't necessarily have to give you exactly the accommodation that you have asked for, but they have to find something that's effective for you to do your job, and to perform the essential functions of your job. So we can go to the next slide and pass it to Naomi.
Thanks. Okay, how do you request a reasonable accommodation? So, while employers may have their own specific processes for handling reasonable accommodation requests, it's understood that an employee may not be aware of what that process is, and they should be able to initiate their request with a supervisor, a manager, human resources, or an ADA coordinator, and they can make that request verbally or in writing. The idea is, though, that however the request comes in, it should be acknowledged as a reasonable accommodation request. And if the person receiving it isn't the correct contact, the information should be directly shared with the person who is the contact so as not to delay the process for the employee. And, some employers may ask people to fill out a standard form for requesting an accommodation. So for people who are considering, writing a letter, you might find that you write a letter or ask for an accommodation verbally, and you're handed a form. So even though the laws don't require you to make the request in a particular way or to use magic words in order for it to be considered a request for reasonable accommodation, there is particular information that the employee needs to share in the process. So at the beginning, you need to tell your employer that you're an employee with a disability. You have an impairment that affects your ability to perform the essential functions of the job or to access the benefit of employment. And then you're asking for what you think you might need as an accommodation. And it's fine if you don't know. Sometimes you know what the problem is, but you don't know the solution, and you're looking for your employer to do that with you in tandem. In terms of describing your disability, I just guess I should point out it's less about stating what your diagnosis is than explaining your disability related limitations that you have that necessitate what it is you're requesting. So if I were just to give the example of diabetes, a lot of people have diabetes, but every person has different associated symptoms. So, one person with diabetes may have their symptoms completely under control with insulin and diet, and another person may have vision issues or neuropathy. Another person may have trouble managing their symptoms, and they have to consistently take time to monitor their sugar and their eating and all of that. But let's say I have diabetes and it causes neuropathy in my feet and it makes it difficult for me to stand. And let's say I'm a cashier at a retail store and I have to stand during my shift. If I want to ask my employer for a stool to use at my register, I would be referencing the functional limitations that I have from diabetes, the neuropathy, the difficulty standing, rather than just saying to my employer, I have a disability or I have diabetes and I need a stool. Because it wouldn't necessarily be obvious to an employer if I just said I have a disability and need a stool, or I have diabetes and need a stool. So in short, when you're requesting an accommodation, the employee is responsible for explaining what the connection is between their disability related limitations and the requests that they're making, as opposed to just saying I have a disability and I have a diagnosis and I need this. Because it's the employee's responsibility to make the connection clear between their disability and what they're asking for as a reasonable accommodation. Next slide, turning over to Juliet.
Thanks, Naomi. So once you request a reasonable accommodation, you're going to engage in what I had mentioned earlier, which is called the interactive process, which is really a core concept of the ADA. So when their employer receives your request for a reasonable accommodation, they're going to reach out to you to begin this process. And that's really an interactive dialogue between the employee and the employer about the employee's needs at work and how they can be accommodated. So when your employer reaches out to you, they're probably going to have a lot of questions. They're going to have questions about how your disability affects you at work. And when you're having these conversations, the diagnosis that you have isn't as important to the conversation as what the result of that diagnosis, what your symptoms are in that affect you at work. So when we practitioners talk about it, we talk about what your functional limitations are. So they're probably going to have questions for you about how does your disability affect you at work? What barriers is it creating that need to be accommodated? And they're going to try to brainstorm with you they're going to try to brainstorm with you different ways to accommodate those needs. They might suggest alternatives to the accommodation that you've requested, and you should think hard about whether those alternatives would work for you. So they don't have to give you exactly the accommodation that you asked for, but they do need to work with you to come up with an alternative solution. Sometimes there isn't an alternative solution and you're going to arrive at an impasse, but in sort of an ideal workflow, you're going to work together with your employer to arrive at a mutually agreeable solution that is effective at accommodating your needs. We can go to the next slide.
Okay. Okay, so when can my employer deny my request? You probably recall from the first slide, Julia talked, quite a bit about this, but it's it's worth repeating. It's important because as she also mentioned, reasonable accommodation requests are always analyzed on a case-by-case basis in consideration of all these variables and all of these circumstances. So every situation is going to be unique because every person's disability limitations are unique. Every job is unique, and as our employment settings. So what's possible in one situation may not be in another. So an important thing I think to keep in mind, and I think a lot of times people lose sight of this, is that an employer is not required to provide any and every reasonable accommodation request that is made to them, so long as a doctor says that a person needs it. That's the beginning of the process, substantiating your need, but there are circumstances under which an employer can say no. Um, so after you've explained the connection between your disability and you've explained what you're looking for, and an employer and provided some medical documentation, if applicable, to substantiate your need, the employer is then looking at the request and they're engaging in the dialogue with you, and then they're expected to try their best to effectively accommodate you. So these situations under which they can say no, as we've mentioned, are the undue financial or administrative burden. Something is a fundamental alteration, something that poses a direct threat to the health or safety of others, or it isn't necessary because of a disability. These are all situations that that would allow an employer to say no. Now, that doesn't necessarily mean that the employee would agree that there is actually an undue financial or administrative burden or a fundamental alteration. But you want to keep in mind all of these things probably before even requesting an accommodation. So if you know that certain things might seem impossible, you might think really creatively about ways in which you can come up with something that would work well. Next slide, please.
All right. So people often want to know next, sort of, well, what do I do if I think I've been discriminated against? And I think the first step that you want to do is think really hard about what happened to you. And ask yourself, is this something that happened to me because of my disability? We get a lot of inquiries at our office from people who have had something bad happen to them and they have a disability, but those two things aren't necessarily connected. And that's not discrimination. And it isn't protected by the Americans with Disabilities Act or by state law necessarily. So when we're talking about discrimination, we're talking about something that is because of your disability. So if you're terminated, if you're disciplined, if you have a bad performance review because of your disability, that might be discrimination. And a really great place to start, if this has happened to you, is to contact our office at Mass Office on Disability. Naomi leads our disability rights unit, and they work with people to understand what their rights are under the disability rights laws, including employment laws. And they can help you figure out, is this discrimination? And what are my options? And what are some avenues that I might be able to take before I file a complaint? Ultimately, though, you might need to file a complaint. And in the employment context, that's usually going to happen at the MCAD, which is the Massachusetts Commission Against Discrimination, which is a state agency, or at the EEOC, which is the Equal Opportunity Employment Commission. So equal well, I think I botched that, but so at the EEOC, they enforce federal non-discrimination and employment laws, and at the MCAD, they enforce the state laws. Those are really similar, though, so you can really go to either venue. I will say that both of these processes do take quite some time, and so pursuing some of those alternative avenues prior to filing a complaint might result in a faster resolution of your problem. So back to you, Naomi.
Thanks. Okay, so wrapping things up, um, we're on the next slide. Anyway, it's about how MOD can help. So I'd encourage people who, want some detail about rights and some information on how you could navigate the reasonable accommodation process to check out the Disability Rights and Employment publication off of MOD's website. And the URL is, well, to our website is, it's mass.gov/MOD. And we have a phone number, and also from the page, you can also submit a question online, if you prefer to do it that way. What we can do for someone with respect to an employment issue is we can, sometimes employers call us, but for an employee, well, in either instance, we can discuss rights and obligations in context of what the laws generally say about things. We provide information and technical guidance. But just to piggyback on to what Julia just said, I think ideally people think I'm going to file a discrimination complaint. I'm really mad. My employer is discriminating against me. That's great. But I think a lot of people don't understand that when they file a complaint, they're in for a long wait. There's work to do that's involved in it. And also, you're filing a complaint at a place where the agency is neutral. They're not your advocate. They're there to investigate the facts. So they're going to ask you to produce things in writing. They're going to ask the employer to produce things in writing. So for that reason, the amount of time it's going to take, particularly if you're still employed and want to get this accommodation, a lot of times it's helpful to speak to someone objective, like at someone at MOD maybe, to say, look, I'm in this situation. I'm not sure how to make this request. I'm not sure what I should consider, proactively about what my employer might say, and how do I think this through? Or maybe, a person's already been denied, or they're in communication and they're being asked all these questions and they're not sure whether, they question whether the employer is doing something wrong. We can provide some guidance for that stuff and help people understand ways in which they can request reasonable accommodation. In the various stages of communication, we're there to offer guidance. And a lot of times we can offer some strategies, or maybe think, maybe look at someone's documentation and say, what, I don't think if I were your employer, I would have understood how you described that. It doesn't really, maybe you didn't provide them enough detail about how this is going to work. So, sometimes having an objective person look at it to give you, to help you talk it through can be helpful in turning things around. I can't guarantee that, but we're there to help people discuss it. So, we would encourage people to contact us if they want to, discuss their situation, and the call is confidential. So I think that's all we have.
Thank you, MOD, and all of our presenters. Now is time for question and answers. So I'm going to actually spotlight all of our presenters, because any of them might be answering your questions. I think, no, hold on. I think everybody is spotlighted now. You can ask your questions by putting them in the chat, and I already see one, and you can also raise your hand to ask a question. But please keep in mind, questions should be generic. They shouldn't be about individual, very specific situations that you might be encountering. If you have personal specific questions, you can send them to us and we will follow up with you after the webinar. So the first question is, how long after potential discrimination takes place can a complaint be filed?
I can take that. This is Julia. Generally, you have 300 days to file a complaint with the MCAD.
Thank you. And I see Melanie King, your hand is up. I'm going to ask you to unmute so you can ask your question.
Hi, yes, thank you so much for this. I am just wondering, regarding the slide about the self-identification process and the benefits, in self-identifying, with hiring and promotion and whatnot. I was wondering if you could maybe talk a little bit more about what exactly those benefits are and self-identification in the hiring process. Like, I guess I'm wondering specifically if you are applying to a position with a company that participates in this and you select that, yes, you do have a disability. Does your application go into like a separate kind of file where you're more accessible to the employer? Or like, what kind of benefits are there?
This is Julia. I can take that one as well. So this is really going to be employer specific. So different employers are going to have very different sort of procedures and policies around their affirmative action programs. So I would recommend asking the employer kind of how that would work during the application process, so that you kind of understand what the pros and cons of self-disclosure might be.
Okay, great. Thank you.
Okay. Our next question is from Manley.
Yes, hello. Thank you for all of the information. It's been a great presentation and a lot of information that is needed. My question deals with if someone has a mental health issue and they're suffering on the job, or it happens before or during or after, how do you how do you handle that? Do you do you tell a supervisor? Do you how do you I mean, you go to get medical help, but how do you describe that situation?
I can start, Naomi, and then if you want to jump in, feel free to interrupt me. Does that work? So if you are having a mental health related disability and it's affecting you at work, maybe that's it's tricky because it really depends, which is an answer that lawyers love to give, and people hate to hear. But it's really going to depend on the situation. So it depends first on how it's affecting you at work. And so mental health related disabilities present at work in a lot of different ways. And even the same diagnosis might present at work in a lot of different ways. So someone who has an anxiety disorder might have difficulty with attention. They might also experience panic attacks at work, and you're going to accommodate those two different sort of manifestations of the disability in different ways. So I think the first step would be to ask, how is it impacting me at work? And what is it about the workplace that is becoming challenging because of my disability? And then once you've sort of thought that through, then you can approach your HR department, your manager, to talk about, how to go about getting what you need. If you're really at a loss for, what might help, there are some good resources out there to help identify different accommodations that might work for your particular disability. One that comes to mind is the Job Accommodation Network. And their website, I believe, is askjan.org. Is that right, Naomi? And they have ideas for different accommodations that people have found effective based on different types of disabilities or different obstacles that they're experiencing in the workplace. Anything to add to that, Naomi?
Yes. Well, I mean, that's a great accommodation piece. I don't know if there's sometimes circumstances where there might be an episode where that's mental health related, and then there's some maybe the employer finds that there's a conduct issue or there's been some kind of reprimand for what happened. And I'm going to put a couple things in the chat after I stop talking that might be useful. But the employer isn't required to just overlook a conduct issue because someone has a disability, but I think that opens up a dialogue about what do you need to get things straight, and can we and what steps can be taken to make sure that this is under control. So even if there is some kind of again, it's not allowed to be overlooked, but there could be some conversation about how to move forward and assurances that steps can be taken that conduct things aren't going to happen in the future. I don't know if both of those things answered your questions, but I hope sort of, and I'll put a few things in the chat, or at least one.
It answered most of your questions, so I appreciate that. Thank you.
Can I add one thing, which is really related to prevention and less on accommodations, which is that obviously there are certain situations within the workplace which can contribute to anxiety, and there are policies and protections that employers must have. For instance, first employers of a certain size should have a policy around sexual harassment, which they have to not just protect you from your coworkers or supervisor, but also customers and other kinds of clients that may cause problems. Another is the Occupational Health and Safety Administration requires that especially where workplace violence could be an issue, that there are policies, training, and programs put in place to protect workers, and training around de-escalation and things like that. So there's a prevention side to this, and just wanting to acknowledge that there are workplace situations which can contribute, and that there are some requirements that employers have to ensure that they're putting protections in.
Great. And thank you, Naomi, for putting that link in the chat as well. Our next question, Jada, do you have a question?
Yes, I do. I'm actually calling on behalf of someone, and it's a little convoluted, so bear with me as I try to explain it. First, I want to say I've really enjoyed this workshop, and I was particularly impressed with what people were saying about some of the pressures that you have in an employee situation. This involves housing. This is a tenant housing, no, what is it? Tenant resident commissioner. And that's a tenant who's involved with public housing, local housing authority. And I know this person has been through issues, PTSD, overcome all that, but very much a leader in the community. And when she joined the board, the executive director initially asked her not to vote for somebody for the committee. And she felt very pressured. She thought it was a joke. And then the executive director was trying to be her friend. But it was weird because she's also technically her boss, but this director was, had some really not very clear lines, which, could also be an ethics issue, because she wanted, if the executive committee, they vote on raises and all this kind of stuff. So her calling up and coming to the tenant residents home to say, here, I want you to vote for this person. This person was kicked out of the building, just real stuff. And I know she was having a really hard time whether or not to stay on, because she said, look, I was glad to be a woman of color here, but gosh, I'm not here to be someone's colorful, ornament. I'm here to make changes, because she lives in public housing, but it's even gotten a lot worse. And finally, she did bring it up. She felt uncomfortable, but then after thinking it over, she talked with a bunch of us. And so she stayed on the board, but it's gotten worse, mainly because she said, look, this happened to me, to the board, her board, mainly people who don't live in public housing. This is going on. And the retaliation was swift. They iced her out. She said she felt like she had to go along to get along. And she's never been able to put things on the agenda. She's tried Attorney General. So she says it's so convoluted, she can't even explain everything. She tried to go to MCAD. But when she said when she went to the Attorney General, they said, well, you have to go to the chair. Well, it was the ED who wanted her to pick that chair, who's the chair. I mean, everything sent to be a roadblock. And it got worse where they were telling other tenants about this person. And she even got on the bench, someone wrote her name and called her the N word. And so it's gotten worse all the time. People are saying really horrible stuff about her tenants, and they can all direct it to the puppet, the one who's orchestrating it, and the one who's architecting it is the ED. And she is a municipal employee, and no one is doing anything. Everybody's sympathetic, from the city councilors, the mayor, they go, wow, but nothing is done. And she even went to HUD because one of the people who's been attacking her, single woman with 2 dogs, got into a 2-bedroom federal family housing with a fenced yard for her 2 babies' dogs. And she's been reporting in there like, you need to go to the local housing. You need to go back.
Jada,
She's very distraught.
Jada, what's the specific question?
The question is, what? This is a discrimination. She's a municipal employee. I'm sorry. She could give it better, but she won't come on anymore. But what does she have? Because the things that, from what I could hear you say, well, the attorney generals, MCAD, HUD, ethics hotline, they've all said, go back to the housing authority, which is the problem. And she's a municipal employee. And I think, because I went with her to go to the city hall, they were like, well, no, you're under housing. So what legal remedy? And this is a person who does have a disability. PTSD is a disability, and going back through all this is flaring it up. She's had to be hospitalized. I know of 2 times. I don't know if it's more. So what is her recourse for someone who's going through this? And I'm just very, very concerned, because it's one thing to be on the board, but not to be treated like this. This is quite bad. Massachusetts is shameful.
Jada, I wonder, I'm happy to put my email in the chat to sort of talk a little bit more. I'm a little unclear on the employer-employee relationship, and that understanding who the employee is will help. It sounds a little like retaliation might be part of the problem, which is illegal, and there are definitely steps you can take if you think you've experienced illegal retaliation in the workplace. But again, I'm a little unclear, and I know there's maybe other questions. So I'm going to put my email in the chat.
Yeah. Well,
Please feel
she's a
free to
municipal
email me.
employee. It's called a special municipal employee. Retaliation, creating a hostile environment are the 2 ones that I look up, but I'm not a lawyer. So I don't know.
Yeah.
I appreciate your information. Thank you. She went to
Yeah,
Fair
yeah,
Housing.
and it sounds like a boards and commission thing. So I'm going to put my email in there. Please contact me, and I can reach out to the boards and commission folks as well to see if we can figure out a way to
That'd be ideal.
address
Thank
some
you
of
for
these issues.
listening. I appreciate it.
Thank you, Jody. I do not see any other questions in the chat. Oh, but now I do. Next question is, what advice do you have for a worker who knows that the employer and workplace is insensitive to people with disabilities? Anyone want to take that question? What advice you have for workplace insensitivity to people with disabilities?
I guess I would ask if you could be more specific about what that means.
Right now the question is in the chat. If the person who asked it would like to.
Yeah, I mean, I see it. I just, being in, is it, that's my question. I'm not really, I want to know a little bit more about what it means that they're insensitive? I mean, do they not have an understanding of obligations? Are they not nice? Like, what does that mean?
I think all the above. Like, people are, like, for example, like there are workplaces that people wouldn't. I think the person spoke earlier about PTSD. Like, that's not something that that the workplace is not, sensitive to, or that actually we see a lot of workers that actually had, workplace injuries, but will be afraid to let the employer know. But I think that, in some places people recognize mostly more like physical disabilities, but not, psychological, mental disabilities. So, because I think that, like, because it takes a lot for someone to actually disclose that to the employer, and that could
Yeah.
result in firing or whatnot.
Well, of course it does. Of course, if you, are picking up through other people, or you've heard things that make you think that the employer is insensitive, it's going to intimidate people from, requesting what they need, or having conversations about that. So, I mean, insensitivity could look like a lot of things, but I guess in terms of someone who, um, you know, I think it's hard to be in a position to say, ideally someone should have some training. I mean, there's a difference between sensitivity and, what someone's legal obligations are. And I,
So
I,
what if you know that someone in your workplace were fired, um because, or was let go, whatever, right? Because they told the employer that they have a disability. So you would be like, okay, I need accommodation, but I don't want to get fired.
so the person who saw that someone else was fired, and they know the specific circumstances, and they know that it seemed to be based on something disability related that the employer wasn't receptive to. Is that what you're saying?
Right. But do you have to know that to be fearful of losing your job?
No, I think that generally people are, have good reason to feel intimidated about bringing up a need they have in the workplace and disclosing something that makes them feel vulnerable. The issue is that, the only way to get, to address issues is to discuss them. So I think, for someone who is fearful, I guess, I would say, from my agency's perspective, we would say, give us a call. We can kind of talk you through like an easy way to make the request that you need and try to help you put forth something that works well. I don't think that anyone's going to be able to eliminate fear, because it's a very personal thing. I mean, we all work, our jobs, we spend a lot of time at our jobs, and it's very intimidating to ask for things, particularly if you don't think your employer is going to be receptive. But since, I think if you think your employer is not receptive, if I said to you, why don't you go to your employer and ask them to do an awareness training? I mean, you're not going to do that, right? Because you're not going to think they're receptive to it. Um, so, I don't know. I don't have a lot of good ideas of how you change things or change someone's attitudes, but
Dale, can
in
I can jump
terms
in
of,
too?
yeah, go ahead.
I think when you're preparing, Naomi said to call MOD, get some advice about how to frame your request. I think generally just being really prepared and documenting what you need, what you've experienced, and keeping a record is going to be really helpful to protect you in that situation where you don't really trust that your employer is going to handle the situation appropriately. Maintaining really good records, putting everything in writing, is going to serve you well in those circumstances.
And maybe trying to avoid, use it, the kinds of cautions that we might give to people is, maybe say it this way, and, thinking of other ways to say things, because not putting yourself in jeopardy by saying something that your employer could use against you. If you say, oh, I'm extremely stressed and I can't have any stress, and I might say to you, I don't think I would say it like that, because, there's some implied stress in every workplace, and you don't want your employer to take that from you and say, oh, you're saying that your disability prevents you from feeling any stress, and we can't do that, so you probably can't do this job. So I mean, that's an over exaggeration, but just to point out that there are, and I don't know if this makes you feel better, but if someone can, kind of talk you through it and frame things in such a way that it would be hard for an employer to pick at it, that might be useful. Sorry.
No, thank you for the questions and the answers. We are kind of coming close to the end of the webinar, so I want to remind everybody that we're saving the chat, and we can follow up with some of the questions that we didn't get time to answer live here. And our contact information is also in the chat if you want to ask us a question after the webinar. The final question is in the chat, and it says, do employers need to respond to a request for accommodation within a certain time frame?
I can take that. This is Julia. Employers need to respond to a request within a reasonable time frame, which is a little vague, but everything in the ADA is really gray. There aren't sort of clear black and white. So there's not a specific number of days that an employer needs to respond. Sometimes employers will have policies around how long they take to respond to accommodation requests, and they should comply with those policies. But it's really reasonable. When I train employers, I say, make sure that you're doing that initial outreach to engage in the interactive process, as soon as possible within the same work week, if possible. But that doesn't necessarily mean that you're going to finish the interactive process, within a week. It can take a couple of weeks sometimes, particularly if you need to order equipment or make structural changes or other kind of changes to the workplace.
Thank you. And thanks everybody for attending this webinar, asking questions. We want to thank all of our presenters from the Office of Labor Compliance and Worker Protections, as well as the Massachusetts Office on Disability. Just a reminder that this webinar was recorded and will be available on the Office of Labor Compliance and Worker Protections webpage, as well as the Worker Empowerment Cabinet's Facebook page. And you'll also be able to find it on the Disabilities Commission's YouTube channel and webpage. Thank you, everybody. And that concludes our National Disability Employment Awareness Month webinar. Take care.